Case United States versus Taboada-Cruz. Mr. Martin.
May it please the court, Scott Martin for Mr. Taboada. At sentencing in this illegal reentry case, the district court abused its discretion when it determined that Mr. Taboada's uncharged failure to register as a sex offender supported an upward departure under Guidelines Section 5K2.21. That section provides that a court may depart upward to reflect the actual seriousness of the offense based on conduct underlying a potential charge not pursued in the case as a part of a plea agreement or for any other reason, and that did not enter into the determination of the applicable guideline range. As its language makes clear, the purpose of the departure is to reflect the actual seriousness of the offense of conviction. That's why this court in Newsom interpreted 5K2.21 as requiring some degree of connection between the uncharged and charged offenses, even though a remote connection will suffice. In Newsom,
It's really remote, isn't it?
it's very.
But it's not non-existent.
Your Honor, we don't concede that there is even a remote connection here. The government's only point, their main point is that there's a temporal connection because this is a continuing offense. But in Newsom, this court cited with approval the D.C. Circuit opinion in Smith that said the conduct forming the basis for the departure must be descriptively or logically and not merely temporally connected to the crime for which the defendant was actually convicted. And that makes sense because, if it were not that way, it would sweep in everything in every case like this, a continuing offense case, frauds, conspiracies, etc. And that would go against the idea that departures are for atypical cases and are supposed to be relatively rare. Here, factually, there was no clear connection between the uncharged conduct, failure to register, and the charged conduct, which was illegal reentry. The offense conduct section of the PSR did not mention a failure to register. The PSR did not, for example, say that he avoided registering as a sex offender in order to avoid detection for his illegal reentry offense. This case is not like Newsom, which is the lead case, where the uncharged drug and firearms offenses in that case were logically connected to the charged explosives offenses in that case because the defendants had a history of trading guns for drugs and were all high on drugs the night they stole the explosives. We don't have any kind of connection like that. A failure to register is also not reflective of the actual seriousness of an illegal reentry offense because the two offenses harm different societal interests. In Sanchez-Lejea, which is a case that both parties have cited in their brief, it's a relevant conduct case. It's not involving this particular guideline, but the government in that case was arguing, and I think correctly, that the two offenses here are severable, partly because they harm different societal interests. The illegal reentry statute is designed to control immigration and protect national security, while failure to register statutes are aimed at alerting law enforcement to the presence of sex offenders, including U.S. citizen sex offenders, not just illegal aliens, and protecting the public from recidivist sexual abuse. That's the purpose, the societal interest harmed by that the failure to register statutes are aimed at protecting. I recognize, as I said, that here technically these offenses may have been committed at the same time because illegal reentry is a continuing offense that is only complete when you're found here in the United States by law enforcement. Although, of course, he would have failed to register before the time he was found in this case. It was a continuing offense. But, as I've said, a temporal connection should not be enough to support a conviction. Under Newsom and Smith, the case that's cited.
The government hypothetically had contended that he failed to register in order to avoid detection. Would you still argue that there was a remote connection?
I would argue that that would be a much better case for the government for a remote connection, yes.
That decision was not made here.
That was not here, yeah. If we had a case where he admitted or said or there was evidence that the failure to register was to avoid detection, that would be a different case. What about the government? The government does make a point in its brief that The aggravated felony conviction was for felony sexual battery. That was what formed the basis for his requirement to register. That's the aggravated felony for the illegal reentry. And our argument, that's kind of a little too far removed here to be a connection. Unlike this original conviction for sexual battery, which was the prior felony, the uncharged failure to register did not in any way affect the statutory maximum penalty for the illegal reentry offense. Our position is that the uncharged failure to register is not connected either factually or legally, penalty-wise, to the illegal reentry offense, and thus is not reflective of the seriousness of the illegal reentry offense. Again, also because of the offenses harmed different societal interests. Finally, the government cannot show that the error is harmless. To show that an error is harmless, it's the Ibera-Luna standard that the government has to convincingly demonstrate that the district court would have imposed the same sentence had it not made the error, and that it would have done so for the same reasons. Here, even though the district court stated that it was also departing pursuant to section 4A1.3 of the guideline for inadequacy of criminal history in view of Mr. Taboada's prior immigration offenses that did not result in a criminal conviction, it still remains unclear whether the court would have departed to the degree that it did, that is, to a sentence of 24 months imprisonment, had it not also departed under 5K 2.21 based on the uncharged failure to register as a sex offense. And that was a pretty big departure. I mean, it's 18 months or 300% greater than the top of the 0 to 6 month range that Mr. Taboada was looking at. The judge did not say or otherwise indicate that even if it had not departed under 5K 2.21 based on the uncharged failure to register, it would have imposed the same 24-month sentence after departing under section 4A1.3 of the guidelines. Your Honor, if there are no questions, I will save my time for rebuttal.
Yes, you say time for rebuttal.
Thank you.
Martin, Sand?
May it please the court, Andrew Sand for the United States of America. The district court properly departed upward in this case based on two grounds, 5K 2.21 and 4A 1.3A. I'll start with the main issue in this case, which is the upward departure under 5K 2.21. I'd like to direct the court's attention to the government's sentencing memo in this case, specifically ROA 126 through 127. That is, in that part of the record, it discusses how on April 10th, 2024, the government told Mr. Taboada-Cruz of a potential failure to register charge under 18 U.S.C. 2250. And then 2 weeks later, on April 23rd, 2024, the record shows that the government and Mr. Taboada-Cruz had engaged in plea negotiations, and if Mr. Taboada-Cruz pled guilty to the illegal reentry count, they would not pursue the failure to register criminal conduct, though they would raise it at sentencing. This record evidence falls squarely under the plain language of 5K 2.21, which provides that a district court may depart upward to reflect the actual seriousness of the offense based on conduct that, one, was underlying a potential charge not pursued in the case as part of a plea agreement or for any other reason, and that includes plea negotiations, and two, that did not enter into the determination of the applicable guidelines range. That's exactly what we have here. The government sentencing memo shows that as a result of the plea negotiations, they did not pursue the failure to register as a sex offender charge. And if you look at the guidelines range, the failure to register criminal conduct did not enter into the determinations of the guidelines range. He had no criminal history score. As opposing counsel has discussed, the governing standard here is under Newsom, some degree of connection between uncharged and charged offenses, although even a remote connection will suffice. And in our brief, we discuss two bases for the connections. One is temporal. As opposing counsel recognized, the two offense criminal conduct does occur at the same time. He illegally re-entered this country in August 2023, and he was here for around 6 months before he was arrested in February 2024. During that entire time, he committed failure to register as a sex offender.
What's your best case for the proposition that a temporal connection is sufficient?
We don't have a case that a temporal connection by itself is sufficient, but I would bring your court's attention. I think we have a very different view of the Newsom case, which I think is our best case overall. Two things about that case. First, the court is the legal holding. The legal holding in that court case said that even a remote connection will suffice. And in arriving to that conclusion, this court rejected more stringent requirements, specifically the defendant's factual relationship requirement and the First Circuit's relate meaningfully requirement. And then the second part of that is looking at the facts of the case. The facts of that case were that Mr. Newsom aided and abetted two friends in stealing explosives from their employers. Specifically, he drove them to the theft site and then stored the explosives at his house. Later on, when law enforcement searched that house, they didn't find any explosives, but they found guns and drugs. And Mr. Newsom was a felon. At sentencing, the district court departed upward under 5K 2.21, and the issue in that case was, what was the degree of connection required between the guns and drug evidence to the actual offense of aiding and abetting theft of explosives. It was a pretty remote connection, but that is what this court deemed to be sufficient. The court said that the remote connection was that Mr. Newsom and his friends had previously traded guns for drugs, but not in the instant offense, and that they had been high on drugs during the theft. The court said that was enough for 5K 2.21. So we think, actually, in the present case, the connection is much stronger. You have a temporal connection here that didn't exist in Newsom. The guns and drugs criminal conduct didn't have anything to do with the theft. And then there's also the substantive connection. As opposing counsel recognized, Mr. Taboada-Cruz, in this case, his instant conviction is for illegal reentry following an aggravated felony conviction. That aggravated felony is his 2006 conviction for felony sexual battery in Tennessee of his minor stepdaughter. And that also forms the basis for his requirement to register as a sex offender. So we think that the connection in this case is actually much stronger than the remote connection deemed sufficient in Newsom. I'll briefly address opposing counsel's point about the government's brief in Sanchez-Leja. Opposing counsel takes a quote about failure to register offense embodies conduct severable from illegal entry in time, place, and harm societal interests. They take that quote out of context. First of all, that statement was made specific to the facts of the Sanchez-Leja case, that those facts are not the same as the facts here. More importantly, Sanchez-Leja involved completely different legal issues with different legal standards. The issue in that case was a challenge to 3 criminal history points for a failure to register offense as a prior sentence. The governing standard on that is one of relevant conduct, which encompasses all acts and omissions committed by the defense during the offense of conviction, that's a much higher standard. Here, we're not talking about. Here, we're talking about a discretionary upward variance by the district court under 5K 2.21. The standard, as this court has said, is a remote connection will suffice. That's much lower than the relevant conduct standard at issue in Sanchez-Leja. Just a few final points about the harmless error argument. Even if the district court somehow erred in departing upward under 5K 2.21, it was harmless. The district court provided a separate independent basis for its upward departure under 4A 1.3, which is inadequacy of its criminal history. And the district court specifically cited that separate guidelines provision at sentencing and in its statement of reasons. That provision has to do work here. And here it does do work because Mr. Taboada-Cruz, he has an extensive criminal history, but none of it was captured in his guidelines range. He has his 2006 conviction in Tennessee for the felony sexual battery of his minor stepdaughter. He has 2006 arrests in Tennessee for being an illegal alien and entry without inspection. And even though those are arrests, the PSR details the underlying criminal conduct for those. And he has his 2023 charge for illegal reentry. That charge, the government brought that charge in federal court, but it was later dismissed. So all of that is criminal history that supported the independent departure under 4A 1.3. Pending any further questions, the government rests on its brief and respectfully requests that this court affirm the district court's judgment.
All right, thank you, Mr. Sand.
Thank you.
Mr. Martin for rebuttal.
Your Honors, I just have a couple points to make. One, the government started out saying that this case falls under the language of the guideline, based on conduct underlying a potential charge not pursued. Well, Newsom, of course, was looking at the same guideline when it interpreted it and said there needs to be a connection. So that's what this case is about. We're not disputing the language of the guideline here. We're disputing whether there's a connection. Secondly, the government points out that in Sanchez-Leja that, or argues that we're taking that out of context, the government's arguments. Our position is that the government's arguments about relevant conduct are pertinent here. I mean, we're trying to determine whether there's a connection. And in Sanchez-Leja, the defendant had been convicted of failure to register as a sex offender while he was illegally present in the United States. And the government in that case was taking the position that that does not qualify as relevant conduct, and therefore that conviction, in the illegal reentry case, and therefore that conviction should get criminal history points. That's not part of the instant offense in that case. It was not part of the illegal reentry offense. So yes, while the relevant conduct standard is not exactly the same one that we're using here, our position is it is still relevant, the positions the government has been taking, including in Sanchez-Leja, that these are severable, separate offenses. And we believe that's the case here as well. Unless there's any further questions, I will rest on my briefs.
Thank you, Mr. Martin.
Thank you, Your Honors.
Under submission. Last case for today, Lowry versus Mills.